If we structure your estate planning through the use of a revocable living trust, then we're going to have two videos that are available here. One is for a living trust that only a single person is creating, and another is for a joint living trust that maybe a couple is creating together. This particular video is going to be for a single or individual living trust. If you have a joint living trust, please close out this video and refer to the other videos that are available for it. And separately, this is going to be a shortened version of the review. For a complete version that is going to go section by section, please reference the other video that's available on this website. Now, living trusts are structures that we utilize to avoid probate, that we create now while we're alive, and they're going to continue for the entire remainder of our lifetime, and they will outlive us by up to 90 years. Now, with that in mind, trusts are somewhat dense because when we think about that entire period of time, there are so many things that can change. There are laws that can change, and taxes and assets, and the circumstances of our own beneficiaries might change. So, one thing to keep in mind as you review this document, much of it is designed to address contingencies and changes that can happen later. A lot of the document is not highlighted for a reason, because much of it is legalese, we can call it. So as we go through this shortened review video, I will explain sections that are highlighted. If you'd like to review any sections that are not highlighted, those are in the full video. But we will just tell you to keep in mind that a lot of this is standard structural language that we are always going to include in trusts to account for those potential changes that happen later. So first is don't get sticker shock by the length of the document. Now, when we look at the actual document itself, the very first thing that you're going to see is the actual name of the trust on the title page. Now, if you are creating a new trust with our office, you have complete control over that name. You can name it anything that you want. The legal name of a trust is the trust, what is underlined there, dated the date we ultimately sign it. If you decide to create your own trust, you can control the name of it. So anything that you might want to name your trust is generally fine. In between the words the and trust, 2 or 3 or 4 words, completely acceptable. We actually encourage clients to change the name of their trust because it provides something more unique, but it also gives them some legal privacy because we're going to be putting those assets inside of the trust. And nobody is going to know what this trust does unless they have a copy in their hands. Now, if you're coming to our office and you already have a trust and we're simply updating it, please understand that that name is fixed and we can only keep the name as it exists. Now, with every trust, we're going to provide you a table of contents. In the full video, we go through the entire document section by section. In this shortened video, I'm simply going to explain what's off of the table of contents, what is highlighted here. So 2 definitions to begin. The creators, the owners of the trust, are called grantor. So you are the grantor, you are the owner of your trust. The people carrying out the trust, the people following what is effectively this instruction manual, those are called trustees. Most of the time when you create a trust, you are also the initial trustee, but we have the potential that you're not going to be able to do this forever. So we will have backup or successor trustees that are going to be listed down in Article 3. Article 1 of the trust is going to establish some basic legal foundation. In 101, for example, it's going to identify this is the trust, and this is the name of the trust, and this is the date of the trust. Some really basic legal pieces that people will need to know. In section 103, transferring property to my trust, there's somewhat of a strange section that says that you're giving your trust $10. So we just like to explain to people, when you create a trust, you are required to put something inside of it immediately once you create it. It's just a little nuanced law. So we simply say here that you gave your trust $10. And then our office is going to help you facilitate transferring or funding any of your assets into the trust entity after we create it. In section 1.04 here, power is reserved by you as a grantor. As the person creating a trust, it is yours. You own it, you control it. You can change it as much as you want. You can put things in, you can take things out, you can swap out trustees or beneficiaries, or you can revoke and get rid of your trust at any point for the rest of your life, as long as you are still alive and can understand the decisions you are making. When the grantor can no longer make their own decisions or when they pass away, then the trust at that point is going to lock in and nobody else can change it. One piece that isn't highlighted here, I do just want to note for you, Section 1.05, Grantor Trust Status. One thing to keep in mind is a trust is tied to the person who creates it. It is essentially the purest form of a pass-through. So one little tip that we just like to give people, a question that we often receive after we create a trust from places like our bank is, well, what's the tax identification number? It is your social security number. So for all purposes that you're identifying the trust, you're using your social so that for the rest of your lifetime, your trust does not have to file its own taxes, pay its own taxes, etc. That'll change when we pass away, but for our lifetime, we want things to remain basically the same way that they are. If we are married, have any children, etc., there will always be an article, in this case, Article 2, identifying those people. So there will be names and dates, etc. So just make sure that that information is accurate for you. And if not, we can make any updates. In this trust, Article 3, trustee succession, is going to provide a number of pieces about the trustees that would step in after us, whether we're still here but incapacitated, or if we pass away. So in this case, 302 and 303 are going to identify those backup trustees. So make sure those are the best people for you. And if not, we can update that. The remainder of Article 3 is really the first batch of contingency language we have. It covers specific situations that can happen in the future with trustees, such as what if a trustee wants to resign and not do this anymore? Or what if a trustee has become incapacitated? There's a number of different contingencies. It's typically only a couple of pages. Feel free to read it. And again, that full review video on the website does cover every one of these sections in more detail. Articles 4 and 5 of our trust, in this case, what is in this document, Articles 4 and 5, administration during incapacity and administration following my death. These are sections that are going to basically tell a trustee what they have to do for us before any inheritance moves on to the next places. So in Article 4, as an example, while I'm still alive, this is still my money. This is still my property. If I can no longer manage it, trustee, you step in and manage it for me. If I happen to have anybody who is dependent on me, like maybe I have a minor child, well, the trust can obviously continue being used for their benefit too. But until I am gone, it is still my money and it is still my property. Article 5, when I pass away, there are just some very basic pieces that have to be resolved before we move the inheritance on. For example, we need to handle my last tax return. We need to collect all the life insurance. We need to take care of final bills that I've left. So Article 5 is going to just make sure, trustee, take care of those final pieces first, wrap up my affairs, and then move everything on to the next place. Now, in this version of the trust, Article 6, specific distributions and personal property, there's going to be any number of pieces we might cover here. So as an example, number 1, if I choose to structure something called a specific gift, which is me saying something like, I want my house to go to my sister, and everything that's left over goes to the kids. Or I want $10,000 to go to the grandchildren, and everything else goes to the children. If we ever create a gift, we're going to detail that gift in the trust. So just make sure that the details are correct, and we can always add more gifts or change the gifts that are listed. If I leave behind any pets whenever I've passed away, we also want to make sure we provide something about those pets. At a bare minimum, where do our pets go? We might provide a gift of money that goes with our pets to take care of them. I will also strongly recommend write down any additional guidelines, any instructions about our pets. One of the resources we give to people is a pet memorandum, and it allows us to detail everything conceivable about how to care for our pet if we're gone. So take a look at those documents, and if you ever complete them, just provide us a copy back for our files. And the last thing this article is going to cover is our stuff, our personal property. One of the more challenging tasks that people have to carry out when we pass away is what to do with all of our stuff. It's time consuming and it's frustrating. One of the tools that we're going to give you with our documents here is called a personal property memorandum. It is just a template document. It's in Microsoft Word format. What it allows us to do is identify what we want to have happen with our stuff, from very specific distributions, like maybe I have this piece of jewelry that I want to go to this specific person, or maybe something more general. Take all of my clothing and donate it. We encourage you, take a look at that document, write down whatever wishes you want to write down, and then provide it back to us. The document can be changed by you as much as you want for the rest of your life. Just make sure that you always supply us with an updated version. What your trust is saying here is if I ever create this, if I ever make these instructions, those are my instructions. Trustee, take whatever I have and distribute it the way that I told you. But there is a contingency here in 604, distribution of remaining property. If I forgot to list something, or if I never made a memo to begin with, then trustee, I'm giving you the power. You make those decisions for me. Now, Article 7 of this document, called My Descendants Trust, or it might be called My Beneficiaries Trust, or some similar name in your trust draft. This is typically going to be the most important section of your document. It is going to detail every aspect of who is inheriting and rules about how they inherit. For example, in this situation, we want to restrict that if my children get married in the future, I don't want their spouses being able to inherit any of this. Well, we've covered that. That's a marital agreement. Or maybe I don't want them to look at this as a golden ticket. I want my kids to have to work. I want them to do something with their life in order to earn this inheritance. Well, that's called gainful employment. So who inherits? What are any rules about inheriting? When do they inherit? We may have specific provisions about ages and amounts that they can take and all of that. So this is the most important section. It's going to provide you a foundation for your beneficiaries and how inheritance works. This is our suggested structural language to start. As you may have any additional guidelines, instructions, gifts, contingencies that you want to cover, all you have to do is write those down. And we can either add them into the trust here, or we can even create a separate document we attach to the trust that just itemizes all of your guidelines. So take your most time reviewing and thinking about this article. After that, there's going to be one more article called Remote Contingent Distribution. We have a backup plan at all times. Our goal is we need to make sure if the people that we want to leave things to aren't here anymore, well, where would it go from that point? So in this case, Article 8 is providing a backup plan, and it might be written in a couple different ways for you. In one, we might just use some default language, which says, when I'm no longer here, if everybody's gone, whatever's left just goes to my next of kin, the next closest person to me in relationship in my family. Or we might have it structured where we've actually named specific people or charities or a combination and any percentages of how we're going to divide things up. In either case for yours, just make sure this remote distribution section aligns with your goals. Now, there's going to be several legal provisions after this that are not highlighted. In our complete review video, we are going to cover these. For purposes of this faster one, I'm just going to show you, explain the highlighted sections. So in Article 10, Trust Administration, there's just a number of different provisions here that apply to how a trustee does the job. In 1001, no court supervision, we're saying that a judge does not need to sit above this trust. The whole purpose of doing this planning is to avoid probate. So trustee, you do not have to have a judge supervise. And what is 1005 here? Delegation of trustee authority. Just recognize your trustees are not required to do everything on their own. Of course, they don't have to know and understand every single piece about how to carry this out. They can bring in people to help them. They can have an accountant handle the taxes. They could bring in another trustee, maybe just to handle the investments. Whatever they need, they can delegate. What is 1007 here? Trustee compensation. This is just setting the stage that the person who's serving, the person who is carrying this out, by law, they are allowed to ask for reasonable compensation. This section itself is pretty short. Compensation is fairly heavily regulated by our statutes. So if a trustee wants to be compensated, they're usually going to reach out to somebody like an attorney or an accountant to figure that out and document it. But it is optional. Trustees are not required to take compensation, and we often find that family members and maybe close friends don't ask to be compensated because they just want to help us. And the last section of this article reports trustees fall into a category of people that are called fiduciaries. And fiduciaries have a number of obligations or fiduciary duties that they have to follow. The most important of those is they have to keep immaculate records and they have to be transparent with how they're managing this trust. They have to make sure people understand what is all the money coming in and what's the money going out and what are the assets and what are the debts. So this is typically fairly lengthy, but it's going to provide a breakdown to the trustee of what all of those obligations are. There will be a lengthy section in your trust. In this case, it's Article 11, My Trustee's Powers. This is very similar to that financial, that durable power of attorney, in that there are so many things that a trustee might need to manage for us. So we're going to itemize all of those different powers here. Now, in our full video, we cover all of these item by item, but just generally speaking, we're going to cover everything that might exist in the future, even if it doesn't exist now. Maybe I don't have oil and gas interests. Maybe I don't own a farm, but you never know what can happen. So we want to make sure we're giving the trustee the powers to manage whatever might come up later. Feel free to turn to any of these. They're typically about 1 to 2 paragraphs long. And again, that longer review video is going to give you a more in-depth discussion of them. At the very end of the trust, there's going to be a few things to note. So in this case, 1201, maximum term, trusts do need to end at some point. In Colorado, a trust has to end 90 years after we pass away. So this is just referencing that statute. It does not have to go for 90 years, but it does have to end if it goes for 90 years. In what's 1203 here, contest, this is a very important provision that's going to prevent certain types of fighting. We don't want people to be able to fight and bankrupt the inheritance. So contest is a penalty clause that's actually going to disinherit people if they take certain steps. So take a look at that. That's very important and it works very well. Lastly, what is 1206 here? We always have a lengthy definition section. If you see a term you don't recognize, look it up. So that is the shortened version of the review of the individual trust. Please feel free to turn to the longer review video as you need. Write down your notes, keep us posted as you go through, and then please feel free to proceed on to any other videos here. Thank you very much.